And welcome to Justice Serve TV. I'm Michel Bryant. I feel like something's missing. You know, like when you leave the house and are you missing your keys? Kenney Baden? She is on assignment. I'm guessing most folks know what that assignment might be, or at least have some clue what it might be related to in her representation of Mr. Aidan Carney. That's all we can tell you. It's all I can tell you at the moment. I will say that it is very different, very interesting. Not exactly unusual for this particular defendant. That's all I can tell you. But we're going to soldier on. And I have in my hand here, well, it's actually not this piece of paper. This is a prop. But we do have the brand new filing in the Kelsey Fitzsimmons case. I'm going to hit this. I don't know what's going to, I don't think it's going to do anything. I'm looking at this video. Oh, maybe it'll do that.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
Where is justice? Will we ever find justice?
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
Justice when we see it. To be and down me, I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All righty then. Hey, one thing we're doing for the days that Kenney Baden is missing on assignment is having very special guest co-hosts. And so I am very excited. I was going to just keep talking until I saw in the chat that people were saying, shut up, bring Ms Demeanor on. I'm not going to wait for that. I'm going to bring her right on here. There she is, Janet, Ms Demeanor. How are you? How you doing?
Fantastic. Heidi ho, chickadees.
I figured you'd throw a Heidi ho in there. Thank you.
Always.
I'm glad you did. So thanks for joining. Thanks for helping out. How's everything going? I know you're doing, and we're going to talk about it a little later, you're doing the Valley trial, right?
Yes. So things have been churning right along on Ms. Demeanor's YouTube channel. We've been covering a lot of different cases. Since Donna Adelson, of course, that was one that I covered, but we've had a lot of other information. I've had some good guests on. So yeah, come on over. The water is warm and we have plenty to discuss.
Yeah, I was going to share this with you because you may recall the tale of two, what I'm calling the tale of two Donnas. This is, on the left is the day before the verdict. On the right is the day of the verdict. So as I've said, what a difference a day makes, 24 little hours, right?
Oh, that woman, man. Oof.
So we were both there. You were there for the whole trial. I was there for about half of it. Saw a lot of the key witnesses from Wendy on down. I didn't see a lot of the final cop testimony, and I did not see the two courthouse, jailhouse snitches.
Linda will get mad if you call them that.
They don't get mad?
Linda will get mad if you call them that.
Linda's not here.
So,
snitches, twitches, whatever. So what was your big takeaway from the trial? Having been in there and right there, you were like 10 feet behind her, right?
Yeah. So one of the big takeaways that I had that is actually kind of surprising to me, and I've thought about it since, I never saw her and Harvey interact ever. And someone afterward told me that they had seen I don't think it was you, but someone had told me they had seen them in the halls kind of talking together. And I said, oh my gosh, I didn't even see that. I literally never even saw them acknowledge each other. So when he did his speech at her sentencing and was just so angry, I was a little shocked.
I know. I don't know even physically how they could have been in a hallway together unless Harvey was allowed in the back, because they brought her in and out the back. She was never always hanging out with the crowd. Remember at the very end when they'd done the sentencing and Harvey kind of approached her area and looked like he wanted to give a hug to the paralegal, I think, right?
Well, they were together all the time. There were several times when I left the courthouse and I would see Harvey and Fulford and oh my gosh, what is his name? Why can't, it escapes me right now. The male attorney,
Yeah.
not Ledford. What the heck was Zellman?
Mr. Zellman. Yes.
Mr. Zellman, and Harvey, they would all be together, and really kind of weird, when you're walking out of there and just boom, there they are, and you're in your car just trying to get out of the parking garage.
Yeah, they would come out that side door and then come down the hallway to the rotunda, I call it.
Yes.
Every floor on that courthouse has that big open atrium-esque area. And I talked to him a few times. It wasn't exactly deep discussion, but, get him to react and just kind of sense what he was feeling and how it was going for him. But yeah, I never saw them. I didn't even see him exchange glances
No,
very often, if at all.
no.
So anyway, and now, we've gone through all of her phone logs and visitation logs from the time she got there in Leon County to the time she left. And last time I checked, she's still in the transition, as they say. They haven't decided yet where to put her. They're still evaluating her, but that could happen anytime. Anyway, he never visited. No. And I know that a lot of time, especially
She
after
had the
was
female
convicted-
rabbi that visited,
did.
and that was it.
Exactly.
How sad.
I just, well, it's a long ways.
mean,
You
sort
have to
of.
go there. I mean,
They all hated Tallahassee anyway.
yeah, that's right. He was not looking for another reason to go to Tallahassee. He was looking for reasons not to go to Tallahassee. Anyway, so that was wild. It was a wild experience. What's your?
I don't think they're done. I still think
was
that
my
Harvey, yeah, I think Harvey and Wendy are still in the hopper. I think it's still a possibility. I honestly believe if there's going to be a next one, I think it'll be Harvey.
Yeah. There are some folks who say that he's going to skate and Wendy will get nailed. What do you like that they have, at least as far as we know, against Harvey that suggests to you that he's going to be next?
The conversations that were recorded that I had not seen before with Charlie and some of, what's the word for it? The interactions that he'd had makes me believe he was a larger part.
Yeah, there were some new things that came out in Donna's trial that led me to a similar conclusion. To me, I kept focusing on what I call the pool meeting, the meeting where they squirreled themselves away in the pool area where they couldn't be recording with their audio or video. And it was like Don Corleone, meeting the inner circle.
I don't know if you have heard or seen Drina's interview that she did.
I saw part of it. Joel did an interview, right, on Surviving
Yes,
Surviving.
yes.
Yeah,
And
I saw some of it.
And after that, yikes. She absolutely believes that Harvey is the mastermind behind all of it. She looks at him as kind of like a mafia don, kind of. And I don't look at him that way at all. I kind of sadly look at him like he's a little bit of a buffoon because I think his wife has run everything in his life. And he just kind of goes, okay.
Yeah, where do I send the money?
Exactly.
And he looks like kind of a low-key, quiet, mousy kind of guy. But when he gave that statement at sentencing, it was fully throated. He sounded,
To say the least.
Yeah, it was surprising on that level. Even when I had talked to him a few times, it was much more just whispery and.
Oh yeah, he held the door open for me the one day going into court. So weird. So
Remember that
weird.
day he got the pizza? Remember he got the pizza that was in the press room next door?
Well, I was never in the press rooms. So.
Yeah, it was. I called it the press closet. And you could have gone in and out. Nobody cared. There were probably 4 or 5 of the local folks that were in there. I'd hang out there occasionally. But they had pizza one day, and Harvey popped in and grabbed a slice. So,
How do you like that?
anyway, we'll probably get into this again if the next round 5, I guess it would be, if that happens. And a
Yes,
lot of folks
indeed.
sure are hoping, whether they think it's based on what's out there or not, that Wendy is next, just because she is.
There is some evidence that I believe if I were her, I would be concerned.
Things that we've seen in the trial, or something else
Yes.
you've got. Yeah.
Yes.
Yeah,
In-
every trial, we've seen more stuff that
Yes.
suggests she's deeply involved. Just a little bit more, a little bit more, a little bit more, and then of course we see her every time testify, and she's so hated She's just very despicable to watch. Such a snot. She's a snot, and nobody likes that.
She's an elitist and feels very entitled.
As they all have, as the dominoes have fallen. Yeah. All right. So speaking of snots, and this one happens to be on the bench. Hey, Judge McCarthy, who is the judge from Essex County that put Kelsey Fitzsimmons back in jail where she now resides. And a quick primer on the Kelsey Fitzsimmons matter, of course. She was and is at this moment, although on administrative leave, a North Andover, Massachusetts police officer. She had a child back in February. I get my dates a little bit out of whack here, but at about the 4th month of that child's life, she gets a knock on the door from cops who are taking her baby away because her fiance baby daddy has decided that she's a danger to both herself and the fiance and the baby. And we may get into some of the attachments to this petition, get into that. And if you haven't seen them all, this is really great because they're all in one chunk, so you can scroll through and look at everything you may have been getting piecemeal. It's all here. It's 113 pages of appendix, and it's 36 pages of the petition itself. When I was reaching out to Mr. Bradle to get this, and I apologize because it came in less than an hour ago. And so I'm scrambling. I'm looking through everything, trying to figure out what's good, what's not. And I said, hey, Teach, can you give me a little help on the homework here? Tell me what's really focused to focus on. He said, well, just consider it the greatest hits. So it's all in here. But as I suggest, it's nicely compacted so that remember who the audience is. It's the full panel of the SJC.
Absolutely.
Minus Justice Dewar.
Oh, yes. Our whiskey justice.
She will not be imbibing on this particular case. And so I'm going through this. We'll go through it starting with the petition itself. And, just chime in and give me your thoughts as we do this. And this is also kind of an interesting thing for folks who, they hear the word all the time. It's a brief. We got a brief. Well, unless you have seen it, you may not know exactly what that is. And of course, ironically, most briefs are not so brief. By nature.
Yeah, I'm all about the doc dive.
Okay, well,
I like to have some good documents to dive into.
Let's see if we can satisfy your desire for the deep dive here. Okay, so this is, and I think I could go up one notch here, maybe a little bit. There we go. So here's your basic cover page. Okay, looks very different than a normal filing that you'd have with a traditional lawsuit, either civil or a criminal complaint. I mean, this is the highest appellate court in the state of Massachusetts. And when I say high, sometimes I do think they're on drugs. So you got your table of contents. It lays it all. You want a roadmap, gets the court where you need them to go.
Absolutely.
Right. You've got your common law table of authorities, the case law.
Oh, I like that.
Mm-hmm. You can get your statutes right there where you got those. And then you've got federal laws and regs that apply to the case.
I see ADA is listed there. That's a good thing.
Yeah, see, now that's interesting because Tim Bradle told me that even though he raised that as an issue early on after the trial court snafu, he believes he might be met with you haven't exhausted your administrative remedies. There's been no filing at the administrative level. So it may not properly be before the court, but it's a heck of an idea to put in there. And the other thing is, what is the Chief Justice's name? I want to say Bund. Oh, wait, I got it here. I don't want to get it wrong. But there's a reason that her name flashes through my brain at the moment. She did work on ADA cases.
Oh, yes. I remember
Kimberly Budd.
Bud, yes. I remember you mentioning that.
Yeah, so maybe that'll tickle something for her and help get her, even if it's just to get her where she needs to go, what I mean, without officially acknowledging it. So she was brought into the court 2016 as a regular justice and then made chief in 2020. So that ADA thing could be near and dear to her heart. Okay, so statement of issues. Generally, in this case, remember the standard review, single justice review. They have the right.
Whiskey judge.
Is that what we're going with? The hooch judge, Justice of Hooch. She's decided that the trial court was correct, bottom line, and she applied the wrong standard. one of the arguments that's being made here in this court, in this petition. You can see here whether under de novo review, the trial court erred. And can we have a discussion about the word ERRED?
I say aired.
Everybody on the planet does, but me. So I just,
What's wrong with you, Michael
I
Bryant?
know. See, I'm not buckling. I'm not buckling.
Hey,
I'm not
be
saying,
true to who you are.
I'm not saying Caribbean. I'm not saying data. Okay.
I don't say data either. It sounds like I'm stuttering when it feels like it anyway. I'm a data girl.
Data. I mean, it's always been data. And for me, Caribbean. When Disney changes the name of their ride, get back to me. So check out ERD. That's all I can tell you. Okay. If they've erred in finding that the allegations constitute clear and convincing evidence that no condition of release could reasonably assure the safety of another person, remember it's the dangerousness test they have in Massachusetts. Another weird thing, where Ms. Fitzsimmons was a sworn North Andover police officer cleared to work, had an insignificant record, was accused of one crime for which she obtained probation on a theoretical plea, and denied pointing a gun at an officer, is gravely injured and seriously debilitated from being shot at close range in the chest, and where the allegations are completely inconsistent with the risk of future harm. That is a mouthful of a sentence.
Yes, it is.
That is one of the issues. Another, whether the Superior Court's revocation of release and order of pretrial detention violated 58A and B, where the court revoked the appellant's release and ordered detention without notice, without a request by the Commonwealth or probation, and without findings by clear and convincing evidence that no less restrictive alternatives could reasonably assure the safety of another person, ignoring the due process and substantive protections required under 58A, B, and case law. And the 58A, B, that's this dangerousness thing. Give me your take on that. This is a hearing that they have. I've never seen them before. Maybe there's something with a slightly different name in different parts of the country, but it's a dangerousness hearing to determine whether or not a particular defendant should be allowed to be released under whatever conditions.
I feel like all common sense has been completely lost, and dare I say, in the state of Massachusetts, but definitely in this particular court, because the only individual that she was dangerous toward was herself. And I mean, I don't think there's any real evidence other than the trooper or the police officer stating that she was pointing the gun at him. But I think anybody that's looked into it and seen what the constraints are of that particular area in her home knows that's not a possibility. What he claims cannot happen there. So in other words, you can't believe his take on it. And so from just, plain old, I'm not a lawyer, I'm just a regular person, I'm just a normal mom perspective.
Yep, you and another person in Massachusetts. Yeah.
I don't see where this was a legitimate means of handling her case. And I mean, by any stretch. There's something more to it. We don't know the whole story.
No,
I just don't know what it is.
We do not. All of this discussion we're having, all of these issues being raised have very little to do with the merits, right? And that's appropriate. This is not a decision to be made on the merits. This is a decision to be dealt with on pre-trial issues, custodial issues. But you're right. I'm wondering why Noonan is the officer who shot her.
Right.
A friend, not just a fellow officer, a friend, somebody who's bonded over a very traumatic call that they got in which a mother and child had been the victims of murder-suicide, and she was pregnant at the time. So I don't know was he motivated somehow by others to say what happened? Was he misinterpreting it in the craziness of the moment?
Well, I'll tell you, when I say there's more to the story, there's more to the story with Noonan, and I don't even like to say his name, her ex-fiance, because I just don't like to give it energy. But
I call him the alien, if that helps you.
Okay, I'm good with that. Yeah, I know what his name is. I just don't want to say it. And not only with that do I think there's more to the story, but I think there's more to the story with the judge. I don't understand why a judge would have such vitriol dripping out of every word she said. I don't understand it.
A lot of people are, it's led to great speculation, right? About who she's connected to and what her motivation was for being such a bitch. That's the legal word. So I'm okay. It may even be Latin for all I know. That is odd. And that gets us back to, let me read part of this again, and I will circle back to what I think is the key component of this whole analysis, and that's that damn audio tape. And the final issue, whether the court violated the Americans with Disabilities Act by ignoring the federal mandate to provide reasonable accommodations to disabled individuals in a pretrial probationary setting where undisputed medical evidence demonstrated that the ordered Scram breath testing device caused the appellant significant physical pain and difficulty in compliance, and where the court failed to consider routine available alternatives such as standard urine testing. So, and I will point out again that we here Justice Serve TV have pledged to pay for whatever that alternate testing may be.
Yes, thank you so much.
Yeah, it was a no-brainer, as they say, to take that little item off her table, of the issues she's dealing with. And so whatever it may be, urine testing, some cuff, some blood testing, there are alternatives. And for those who don't recall how outrageous and inappropriate Judge McCarthy was in just poo-pooing those mentions and comments as if they never happened. And in her order, which we may get to, it's attached as one of the exhibits, she just flat-ass lies and says that there was never any alternative testing suggested. Well, that's a lie.
Well, she also said that Kelsey was refusing to do the testing.
Yeah.
And that wasn't the case at all. It was very clear they were voluntarily going before the court to be good people, and they got, trounced for it.
They were just
that just makes people
proactive.
Yeah, it's just going to make people lie in the future. Maybe that's the problem. Is you behave this way and it causes all the crazy behavior that we've been seeing in Massachusetts.
I don't know. I have no explanation for the lunacy that's happening up there in every corner of the state now, it appears. So, basic recitation of the facts here. June 30th, that's when she was shot in the chest by her buddy. The order was obtained by her fiance ex parte. And if you haven't read that, it's a doozy. Requiring Ms. Fitzsimmons completely without notice to give him custody of her 4-month-old newborn, forfeit her firearms, and consequently forfeit her job, her upcoming wedding. At this point, I'm not sure she had a problem forfeiting the wedding and the relationship.
Yeah, I'd say so.
But that was part of the concern. And if you read that affidavit filed by him, he acknowledges in there that she had threatened to harm herself.
Right.
And
yes.
If nothing else, that gives some credence to her story, which was she pulled the gun just to do that. So it, in some small way, does support her version.
Yes, indeed.
She contends she would never point a gun at a fellow law enforcement officer.
I believe that.
I do too, much less the officer who she considered to be a friend. I think if there wasn't that history with Officer Noonan, it might be a non-event. It might be a non-factor. Just if it was generic officer. And here's, of course, the beauty of their whole operation there. No body cameras, no other witnesses to the events in the bedroom. Yeah, because body cameras, those are expensive. I mean, those cost maybe $50 each. So,
well, we'd far rather spend the money on frivolous prosecution.
Yeah, that's true. Well, look at how, I think that was most of that money went to the experts in the Karen Reed case.
Well, Hank got a lot too. So
yeah, Hank got, $600,000 or so for him. And almost that amount for the experts they brought in. So
and all those troopers and police officers and all the overtime that they've been paid over the years. Yeah, they'd far rather do that than
you got to set your priorities.
You
have to. You can't buy everything. Grand jurors. This was another annoying note. The grand jurors returned a true bill on only one count of assault by means of a deadly weapon. And remember, they wanted murder. They wanted a murder charge, and even the grand jury said, that is not a ham sandwich we're going to indict now. So that didn't happen. So they got all that done. September 8th, motions back and forth. Remember, September 11th was the day. That's the last
Oh,
day
yeah.
that she was out. And so we're coming up. Tomorrow will be 2 months. And
Unbelievable.
it really is. I can't believe it's been so long. But remember, it was 180-day, 6-month pre-trial incarceration. So the theory being the trial will be held in that
Right.
period of time. We're so far from that happening at this point. I'm not sure what to make of the actual scheduling. Let's see.
It's hard to understand where they would even start with it because they've convoluted it so much now.
Well, the case itself, it has a relatively finite set of facts, right?
Sure.
What happened on that day when they went to the door and what happened in the 15 minutes after that.
Yeah, the problem then is you getting to that point that you can, because you've screwed everything up on all of the things that are not related to the direct facts of the case. That's what the problem is.
Well, yeah, there's a lot of collateral damage. There's no doubt about that. And so, I think everybody who's concerned about her and the way she's been treated is just like, let's get her out of jail.
Yes.
Then we'll start the process.
Get her with her baby.
Off-ramp. Yeah. Yeah, that's even a secondary issue.
Oh, my
just
gosh,
because she gets out of jail doesn't mean she's going to see the baby. Remember,
that's exactly my point.
He currently has sole custody, and she has been, if you even look at we were up there when it was 2 weeks ago, we were recording that hearing, and the agreement they came to gives him custody, and it was a joint agreement.
Yeah.
And I think the reason for that is get her the hell out of jail. We'll revisit this.
Yes.
I think, I'm no genius here, Janet, but I think getting out of jail is a changed circumstance that might allow you to go back to the probate and family court and say, hey, and this judge, Judge Black, Mary Black, sweetie, she was nice. She was thorough.
She gets it.
Some people got a little annoyed because she took so long to kind of get into it. Because
I don't mind that.
Reading all of their papers, like she hadn't. Oh, it's a surprise. I've never seen this. So it was kind of a lot of anticipation. But when she got to it, I think she did the right thing. And I would love to, there's been some discussion about it being moved to, which county is it?
Oh yeah, out of
Essex County. I don't think that's happening. Even the follow-up
Isn't it
brief that was
Middlesex?
filed. Middlesex, very good. You got your Massachusetts counties down there.
I feel like I've lived there.
Really, they've decided, I think, between the parties that bullshit about, well, I got my driver's license now in Middlesex, and I've got all of these last-minute attempts to further wrest this child from mommy ain't going anywhere. And so I think that's a plus. And I don't mind going back to Salem. It won't be the week before Halloween, which it was last time, which is a whole different circus. Okay, so this was an important point made. This isn't a footnote. Footnotes are always critical. The Massachusetts sentencing guidelines provide for a probationary sentence in Ms. Fitzsimmons' circumstances in the little or no record category. For the one count in this case, for the maximum 5-year felony with concurrent district court jurisdiction, means dripping wet, worst case scenario, she gets hit with 5 years, right?
Correct. Got
Unless the court acts here, she will have to endure pretrial incarceration on a case where if she pled guilty, which she will not do, she would almost inevitably get probation.
Oh, for heaven's sake.
So this sole charge does not warrant detention or any of the 58A findings. So that's just another, what the hell's going on here, Judge?
Yeah.
I mean, how can you ignore the charge that is now officially pending and not apply the analysis we see here, which basically says, even if she's convicted or pleads guilty, she's probably not going to do any time.
Right.
Hey, and I
Makes
think a lot of
perfect sense. Maybe the judge was drunk.
Oh,
I mean, I see a lot of that now.
Maybe we could get the judge on the scram.
Maybe the judge needs to be the whiskey judge instead.
I saw something that Judge Dewar did, some sort of public acknowledgement awards. And she seemed like a lovely, perfectly fine, lovely person, but she just dropped the ball badly.
Sure did.
Yeah, and it just looks like, oh, it's a robe covering for a robe.
Right.
and I don't even know if that's true. It just looks like that. It just smells like that.
You never want the appearance of impropriety,
Very
no matter
good.
what. And so you always want to make sure whatever your behavior is above reproach, and that no one would ever connect dots to think that there would be something like that going on. That is not something that happens in Massachusetts.
Well, that's just it. In Massachusetts, at this point, everybody thinks the worst.
Yeah.
No matter what it is.
And they keep proving it.
They keep setting new goals, and the bar continues to be, just when you think that I can't believe anything could be, oh, there it is, something worse. Yeah.
Yep. They're like, hold my beer.
Okay, so here's the reason for the attempt to get the condition changed and do something other than blow into the scram. Each time I blow into the device, it causes me extreme pain due to my broken ribs and the fact that my lung is not completely healed from being shot. I have also developed significant anxiety that my inability to blow into and complete each test will trigger a warrant for my arrest. I can see how that might be a little
I get that too.
stressful. I feel that putting my body through the exertion this test requires is causing major setback to any healing progress I have made. And then her mom filed an affidavit as well, because she's living with her mom, which is also key. And they've made that argument to the court that it's not like she's just going to wander off.
Yeah.
We know she has a house. I don't know if it's closed yet. It was in contract, and that was another issue that was being fought over.
Right.
Because the alien wanted the money.
Wanted all of it, and they said, no, you have
because you've got a
$50K.
little baby for 18 years to take care of it.
$12 a week. How about that?
I know. I do like that decision. That was what a slap in the face that was. I witnessed, this is the mom, I witnessed her struggling extremely with blowing into this device. There was one occasion where she almost passed out. After that occasion, she became very shaken and sick for most of the day. I'm confident that a large part of that is just the stress of thinking, I just had a problem doing it. What happens next time? I can't believe it's going to get better, right? Every time it's going to get worse.
Yeah.
Let's see. Oh, here we go. This was the key that I teased way back. Ms. Fitzsimmons respectfully submits that it is important. You can tell it's important. Why, Janet? It's in bold.
Bold.
Yeah. For this court to listen to the recording of the trial court bail hearing, which recording was submitted to the SJC on a thumb drive. It was also submitted to the hooch judge, and nobody knows for sure whether she listened to it. I say she didn't, because her order clearly referenced the transcript.
Yeah,
of the
I don't
hearing.
think she listened to it.
So why would you not say I listened to the audio if you listen to the audio? So Tim Bradel is doing his best, short of going there and,
making them.
He could do it. What was that movie where the guy's outside the girl's house with the boombox?
Oh, Say Anything. Say Anything with John Cusack. Yes.
There you go, John Cusack. So I can see, maybe I'll do that for Tim Bradel. I'll go down there. I'll go to the SJC. I know where it is now. I'll just stand out there. I'll have that baby just blasting.
Please let me be there for that.
That would be fun. Okay, let me put that in the.
We need a Say Anything field trip.
Wouldn't that be amazing? The challenge is, remember, there may or may not be an oral hearing,
right?
An in-person hearing on this. If there is, now you're really tempting me, because I would definitely go.
Don't tempt you with a good time, huh?
I think it's perfectly legal. I checked the First Amendment. I think I could stand out there with a boombox just blasting that hearing audio.
That'd be awesome.
Oh man. Okay. Put a pin in that. Okay. Let's see. The thumb drive with their 221 memorandum. That 2:21 is the local rule for the actual single justice appeal. The single justice apparently only reviewed the transcripts, according to Michel Bryant. Later provided by the Commonwealth, and was not able to appreciate the actual treatment of the defense and the probation department, which it made clear by listening to the hearing culminating in the judge departing the bench while defense counsel was mid-argument. It was crazy.
Indeed.
It was crazy.
It was insanity. I couldn't believe when I listened to it. I was like, what just happened?
And then you hear, Ms. Fitzsimmons started to break down, right?
Oh, yeah. Oh, gosh, yeah. I don't blame her.
The audio. And then the probation officer, who also has some documents in the appendix, his back and forth with Mr. Bradel regarding alternatives.
Oh, yes.
So important.
Wasn't his name Saturday?
What's that?
Wasn't his name Saturday, Mr. Saturday?
January.
January.
What
I
the
knew
hell
it
you
was
doing
something like that.
Saturday? Was it Mr. Tuesday? I don't know.
I'm just
Yeah.
a normal mom. I can't remember
Just-
everything.
Oh, Janet. Okay. The court shut down the probation officer, Mr. Tuesday, cut off counsel, and walked off the bench while undersigned was arguing for his client. In writing, she accused the defense of manipulating the situation and repeatedly misstated the record. What she did, I remember she latched on to Mr. Bradle's reference to the Eighth Amendment and cruel and unusual punishment and torture, and she just threw that right back in his face.
Yeah, it was unbelievable. I don't know how.
Oh, torture, eh? We don't want to torture her.
Right. Of course not.
So it's much better to throw her in jail. We're not torturing her.
Yeah, that's way safer.
Of course
And,
it is. You're
good to
cop.
keep her away, away from her child and all that. That's a way better choice.
It is. Oh, somebody decided. Who says that? Oh, Sherry Schreiber, of course. She said, "Damn it, Janet, are you a big Rocky Horror fan?"
I tell everybody if they are going to say that, they have to finish the rest of the phrase. And what comes after, "Damn it, Janet," is, "I love you." That is what is said. So I make everybody say that.
Well, very, very good. So you're definitely used to it happening. Linda said they're doing that as a play.
Rocky Horror is fantastic. I'm a theater geek, so I
It's
of course
at some theater. I can't remember the one that used to be Studio 54. Anyway, it's coming out this season, so that ought to be wacky.
Yeah.
And then of course Judge Dewar denied the petition without a hearing. Okay, so anyway, this thing is laid out. We're just talking format and formalities. This is the way these things unfold, and this is the way the court expects them to be done. Remember, there was a page limit on the paperwork to be sent to the single justice. It was 10 pages.
Yes.
No such limit here, apparently. I didn't see anything, and they went to 36, 38 on this petition. The affidavit. Have you seen the affidavit in a while?
I have not. No.
The alien put together.
No. I've been careful to give too much energy to him.
Yeah, it's it looks like a ransom note. An affidavit full of shocking lies. In no free society, I like that already, should a person be able to go to a court, fill out a form, and send the police to a new mother's home and take a baby away from her without any opportunity to be heard. If there are allegations of imminent bodily harm, that is a matter for police and 911, not the court system listening to one side of an issue from a private party with their own agenda and ulterior motives, seeking a leg up on future custody matters. Harumph.
It's unbelievable that an individual can just go and have this done.
Yeah, and there are these ex parte orders are not unique to Massachusetts. They may be more liberally allowed there, or more liberally received, because really they don't mean anything unless a judge bites, right?
It's interesting to me that doesn't appear to be any sort of follow-up of asking, well, what have been instances in the past that require or would warrant a restraining order and for her child to be taken from her. I feel like there should be a history of some kind besides just I come in and I say it and therefore it is.
Yeah, and the key again, especially to the alcohol monitoring, was remember his affidavit was, I believe, June 30. And on June 28, she's in Maine for, ironically enough, her bridal shower.
Yeah, bachelor or was it a bridal shower? Or was it a bachelor
sorry, you're
party?
right. You're right.
Even worse, a bachelor party. Of course, everybody's going to get drunk.
Yeah, and so without any real detail, she was apparently just embarrassingly wasted, and therefore that incident was included in the affidavit, which certainly the court made much more of, maybe, than was necessary. And she kind of clung to that as the reason that we have to have this scram testing, because you're obviously out of control drunk. I always, when I see footnotes, I always go backwards from the footnotes. Officer Noonan, let's see if I can highlight that here. Officer Noonan stated Ms. Fitzsimmons, kneeling on the floor of her bedroom, lunged behind a door and reappeared pointing a firearm at him. Fitzsimmons adamantly denies ever pointing a firearm at another person. Footnote, it's notable that there's no door to or in Ms. Fitzsimmons' bedroom, and I've seen the pictures now. It's not even a pocket door.
That's what I was saying earlier, is that it makes it so you automatically don't believe Officer Noonan's account of what happened.
Yeah, because that's beyond misperception because of the, the moment. That's very specific. That's I think technically that's what you call a lie.
Big fat one.
And it's because that was a design element. Somebody decided, and because they put the molding back in, I'm dropping into my DIY mode here. They had to take the door out. It's not just like the door's off the hinges.
Yes,
it's like designed without a door.
Yeah, because it's got finished molding all around it.
Exactly.
Yeah, I know what you're talking about.
Exactly.
Mr. Demeanor used to be a finished carpenter. So.
Well, there you go.
So I know a lot about it.
Did millwork? Did he?
Well, he worked in a millwork department at one time.
Okay. Yeah. Okay. Then you know. When you know.
So yeah, there is no way that what he claims happened. It's just bovine scatology, I say.
So then you ask the same question I've been asking, which is, okay, what's his motivation? Was it to support the bigger story? Was he afraid that he would then be the one charged or at fault for excessive force?
Yeah, I think he panicked.
In their appendix, they've included the police. I zipped through there, but they included the police officer rules of conduct, like when you can use deadly force, etc.
Sure.
So he might have been concerned that without his version, it looks like he's the bad guy. I still think
he is the bad guy,
but it looks like without reason. I think if somebody is waving a gun around and it's in my general direction, most are going to think I have at least some argument that pulling out my weapon and defending myself is legitimate. But if you don't have that part of the story, then Correct. It sounds like you're just a cowboy in it, right?
Yeah, that's not good. That's why I think he came up with the story that he came up with, to be perfectly honest.
Yeah, well, that's what I'm wondering, if it was out of fear or,
Yeah, I think he just panicked, made a bad choice in a split second, and
now he's covering his own ass.
Yeah, I mean, I'd kind of go back to Alec Murdoch and, oh, what a tangled web we weave. And he said once he lied once, then he had to lie again and again. Well, he didn't have to, but he chose to. And that's kind of this situation. Once you decide that's going to be your story, you got to keep spinning that web.
Yeah. Well, every time I think, well, it is Massachusetts, so I think bigger conspiracies and others pulling strings, and somebody may be suggesting the story to him because the department will be looked at differently if he's an instrument of their evil doing. Because once they start looking into the reasons this encounter took place, everybody involved looks bad. It looks like they're just rash. I mean, including, why are you calling the alien 10 minutes after you get there? He should be nowhere around. Nowhere.
No, if he's truly afraid.
That too. And they should have no
one's talking about that.
Family services person or somebody there. Yes. That would be the person. An independent person should take the baby, not the guy who's claiming that he's at risk and the baby's at risk and even the mom's at risk. He should be nowhere near that scene.
I've never understood in this story why no one has ever asked that question. If he was in such fear, why the heck was he there?
And I guess, again, what's his mindset if it wasn't just evil? But it's like, well, the cops are there, so I guess I'll be okay. Okay, all right. So for those who don't remember the actual nature of the injury, gunshot wound, this is in the footnote 5, gunshot wound to the right hemothorax with retained bullet fragments in the right upper back. Moderate right hemothorax requiring chest tube placement, I think, or lung collapsed. Right middle and lower lobe pulmonary contusions with active bleeding. Grade 4 hepatic trauma with active bleeding from the right hepatic lobe. Comminuted right posterior 12th rib fracture. Right anterior 11th rib fracture at the contracostal junction. Oh, costochondral. Sorry, I got my junctions confused there.
Hate when that happens.
Yeah, that's painful. So I wonder why it hurts her to take a deep breath. I mean, most people who've blown into those, and I had one here. I actually put it in my car just for fun, just so just to have with it. But it's like a consumer version, but it still takes a mighty long, sustained blow.
Well, let me tell you, I'm a severe asthmatic, and I'm struggling with asthma right now. I have been for the past week or so,
Okay.
and I don't think I could do it. I would immediately having to push that much air out so quickly. It would immediately send me into a coughing fit, and I wouldn't be able to do it.
Yeah.
And then I think my son, when he was younger, he broke a couple ribs, and he couldn't even take a deep breath, let alone. And he's a tough cookie, but he was like 11 at the time, and he was just like, "Oh, Mama, I can't do it."
Is that a skateboarding accident, bicycle accident?
Dirt bike.
Dirt bike. I was getting there. Okay. All right.
Went over the handlebars.
Okay. Yep. I could see that. Yep. I could see that.
So there are a lot of people that wouldn't be able to do this because it does require so much hard breath.
Yeah. Yeah. It's not pleasant, even if you got all the lung capacity you need.
Yeah.
It's just a weird, it's almost a drowning feeling, like as you get at the end.
Yeah.
And it's uncomfortable. And I get it for the right reasons, but not for the wrong reasons. Chicopee, I was outside Chicopee a few days after they locked her up in there. We did the show from there, a lovely giant institutionalized building. And she is, according to her dad, who I spoke to at the hearing, she's in, I guess they would call it ADSEG, administrative segregation, or whatever they call it. It's not being in solitary confinement, but it is
security or anything like that. Yeah.
Right.
It still stinks.
It's for her safety, and she's not in Gen Pop. Why would that be? Well, I don't know, because the court didn't seem to give a shit. The court ignored the increased risks inherent in incarcerating a police officer and a former corrections officer. The defense learned on September 28, 2025. Remember, this would be then 17 days after, right? 17 days she's been in.
Yes.
She has, in fact, been targeted. Now, she's only out about 1 hour, like it's go to the shower or whatever, very limited interaction. And I think that's probably even less now because of this. 9:15 on September 24th, a biological male identifying as a female. Don't get me into all that. Threatened petitioner saying in her presence, "I found out something about that bitch." And later, directly to Ms. Fitzsimmons, while walking to his cell, he began pointing and screaming at inmate Fitzsimmons, who was currently on the rec deck, stating, "You PC bitch, you best check out who you're fucking with." I don't know. What's a PC bitch? Is that like politically correct?
No, PC is, somebody told me it has to do with,
help me. Anybody know what that is?
Oh my gosh. Not corrections, but because of what her status was.
Oh, like protective custody. That's it.
Protective custody. Thank you.
That's it. Okay.
Sounds
I've answered my own question.
Use my hands a lot and it'll come out.
Okay. So now you PC. Okay. Got it. Now I got it. Okay. Let me see if I can get us moving again here. Where are we? There we go.
Yeah. Now the chat comes to the protective custody. Leave us out there hanging all that time.
Yeah. Come on. Summary of argument. Talk about her. This is apparently where I ran out of time before we got on the air. So
you're good.
We're now reading this together.
Cold.
I'm trying to hit some of the high points without truly reading every single word.
Yeah, it looks like this is talking about how she became corrections or in the law enforcement.
Yeah, and
no legal basis to hold her in prison as a pretrial detainee. There isn't.
All of these things ignored again by the trial court. Oh, and then this is a continuation of the prior footnote. The fact that petitioner will continue to be targeted due to her profession, and I like the highlighter, and is at enhanced risk of harm 24 hours a day. There is no legal basis to hold her in prison as a pretrial detainee, especially given her law enforcement history. She's under enhanced risk of harm, even death, and should be released forthwith. I've told LKB many times that, I'm holding my breath, no pun intended, waiting to hear some horrible story about how she's been injured or worse. I was glad to hear from her dad that day that that's less likely because they are, separating her. PC, I understand. And so that's a good thing. And
Yes.
and I just, again, I can't believe it's been 2 months. Tomorrow, 2 months.
I can't believe it's been 2 months either. I mean,
Imagine
time
what it's like if you're
flies.
in there.
Oh my
Probably feels
gosh, I
like
bet.
2 years.
Yeah, it doesn't. I'm sure time doesn't fly when you're in there.
No, no, no. Feel free to jump into if you see anything as I'm going through this that you think is interesting.
I'm just
shout
kind
it
of
out.
glancing. She was tiny, 5 feet tall, 110 pounds.
Yes, yes.
Just that he was her not only a colleague but a friend.
Yep, because of that.
Can't take a deep
shared
breath.
experience.
Gravely injured and presently scheduled for a 5th operation.
Yeah, if they'll
Oof.
let her do that. You heard that
Yeah.
story too, right? About the ankle monitor. I'm sorry, she can't take that off for surgery. What?
This is so ridiculous. It literally, if you put this in a movie, people wouldn't believe.
No, they
this
say
is
no.
reality.
At the scripting level, the producer, the studio would be like, no.
This is not believable.
Here are the first notes. Fix that. Fix it. Alcohol, the irrational focus.
Yeah, it really was.
Referencing that one event. Drinking the week before at her bachelorette party. So.
And she probably hadn't cut up and done anything for quite some time up to that point because she was pregnant. And
right.
then,
so this was a kind of let loose,
Yes.
very natural experience. Who ratted on her? Was there? I can't remember. Was there an event up at the?
I feel like there was a video.
Oh, like there would be
a social media video. I'm not positive,
okay.
but I could just be completely making that up.
Social media.
I feel like I remember reading.
Just made that up. Yeah. And then it was posted, and then the cops saw it. I mean, that's just the way things are these days, unfortunately.
Yeah, a bachelorette party is hardly a bellwether of ongoing alcohol abuse by a new mother and full-time sworn police officer. That's exactly what I just said. Yeah.
That's right. Not unless you're going to them routinely. You're having your own bachelorette parties once a month.
Exactly. Oh, they're saying in the chat that the fiance was at the
so it's only
bachelorette
his
party.
So is there video?
I would.
There's got to be some video.
I would think
it may
there
be
is.
helpful.
Or pictures. Could be.
It could be that his word is worse than reality.
Yeah.
I'd love to see that video.
Yeah, this is the whole alcohol thing is ridiculous.
Yeah. And again, it was clearly the focus of not just the conditions, but then her reason, Judge McCarthy, her reason for putting Ms. Fitzsimmons back in the slammer. The foregoing factors strongly militate against a dangerousness finding. That's what it all gets back to, is this dangerousness.
So when I say the judge's name, she's McCarthy Naaman, and I always have to say,
I always skip the Naaman part.
Well, I say it because I say it like Naaman.
Oh, like Newman. I got you. As a Seinfeld fan, I respect that. I appreciate that. I noticed in Dewar's decision,
the hooch,
she didn't use the hyphenated part of her name.
Oh, really?
Yeah, I thought, something wrong. I mean, hyphenated, I'm guessing, is a married hyphen. I may be wrong, but it's not like Anne hyphen Debbie. I mean, it's clearly 2 last names, McCarthy,
right.
Naaman. But I may have to go back to Naaman if I use your
Naaman.
Naaman.
That's exactly how I feel.
That's it. Talking about her staying with her family. She has everything to gain by staying with her family and fighting these. I like that word. Oops, get out of there. Abominable
charges.
Yeah.
Yes. Way to go, Tim Bradle.
Yeah. Colorful. It's clear that
a picture.
Pictures.
Yay!
Now you got my attention. See, what a sweet picture. And that's a cop car. That's a nice car. They have those low profile things on top.
She looks happy.
Yeah, she loved her job. Obviously, she did the 2 years as a correctional officer because it helped her get to be a police officer. It was not.
It's not.
I don't think it was a formal prerequisite, but I think she knew that would help.
Yeah, it's very, very common for individuals to be corrections officers prior to becoming law enforcement.
What a horrible job that is. And she was in. I'm trying to remember some of the details. It was a 110 man facility. She wasn't even in a women's facility.
Oh, good grief!
It was a men's facility, and so she had to be, I guess, as tough as you can be, being overnumbered dramatically.
Absolutely.
male inmates. So that'll toughen you up for the street, I would think.
Yeah. Quick, fast, and in a hurry.
Yeah, I've said many times, I would not do well in prison. I don't even want to be a guard in a prison.
No,
Just-
I don't even want to be in one. I don't even
No.
want to talk to somebody that's in there.
I've been to a number of them,
I bet you
interviewing
have.
your casual killer here and there.
Like, I'm not going to go see Donna.
No, I would go see Donna. If she would let me, I would go see Donna. I would definitely. You would go see Donna if they let you. You would be there. You would be
I
there.
might. I
Yeah.
might.
Come on.
I might.
Wherever she ends up, let's see where she ends up. Just reading. Just reading.
Yeah, I'm reading too. This is talking about the statute and what the court stated.
Yeah, and the difference with the single justice versus the rest of the gang.
Right.
And I pointed out before with the SCOTUS, as we say, Supreme Court of the United States, it's purely what they want. They get 5,000 requests a year. They say yes to about 100. This state Supreme Court, the default is really that they will listen to it. It's more unusual that they will not. The questions always become in-person hearing, oral argument, and those things are still up in the air here. They were denied without prejudice because now they want to look at this paperwork. I would love if I think they're chicken shit if they don't have a hearing on this, considering the issues involved. And
if there's any pulse at all on what the public outcry is, they would be foolish to not. But hey, it's Massachusetts. So.
Well, that's what I wonder. I wonder about those, what kind of conversations judges have and justices have in Massachusetts when they see all of the lunacy that's swirling around them. Do they feel like we need to be better than that? And let's show people that we are. Or are they like, I'm not getting out there. I'm not going to put myself out there.
Yeah. I mean, I think that there's a possibility that they would be, we don't want them to see everything because there is a lot of behind closed doors, a lot of hiding, a lot of, what's the word? Undercurrent. It feels like in Massachusetts. And yes, it must be reversed.
And yes, it must be. And if you're one of those judges or justices who do the right thing, you got to be embarrassed.
Oh my
totally
gosh.
Embarrassed.
You know what? It's just like being a woman and seeing certain women in positions of power look so awful. It enrages me to see people like Beverly Cannoni, and now I can add Naaman to this, in their positions of power and really making it look like women are incapable of actually handling those types of jobs.
Typical man.
Oh, I'm sorry. Every time Fonnie hears somebody bad-mouthing women, she pops on there. Sorry.
But that's what they make it look like, that women as a whole are incompetent or incapable, and I just cannot stand it.
Yep.
Okay.
Again,
I guess my rant and soapbox I'll hop off of.
I mean, when Bev Cannoni is the standard that people are comparing everybody else to, yikes. Okay, so in supporting its decision, the court resorted to attacking the attorneys on alleged procedural deficiencies and manipulation in its written rulings on the events of September 11, and denying the reconsideration and ignoring the medical evidence. That was the other issue. And so, even the surgeon writes a letter saying, here's how do you get a surgeon to write you a letter, anytime within, the time frame you need it. Not so likely. But they had that, and they had Mr. Tuesday. He had his report, the probation guy. And that was another grinder, that this guy, he's there. It's his job to determine whether somebody has violated or not. And he's helping. You know?
He's like, no, hey, it's all good. That is his job. And I've kind of felt like she didn't even want to hear from the probation officer.
And that's what I just keep circling back to that. What was her motivation? Why is she so pissed off? What is her problem? And I just have a feeling, as with most of these things happening in Massachusetts, we're going to learn. There's something. There's just something. Otherwise, I think she's mentally ill.
Yeah.
Because I just can't justify what she did if there's not something going on in the background that motivated her, and she's loony. Footnote 8, this is accepting 2 exhibits generated after the court denials: the risk assessment by Ms. Tenney, the LCSW, licensed clinical social worker, and the Hampton County Sheriff Department incident reports, both generated after the trial court decisions. Nonetheless, they can be considered. Why?
Because it's the first time.
De novo. And that's it. And that's critical. It really does. To be honest, for Judge McCarthy, Naaman, it does give a chance for her to get her, bad decision fixed.
Yeah.
Now, of course, then Tim Bradle's got to go back in front of her, right? That ultimately. So he has also asked that she be recused. Whether that's going to happen or not, who knows? One thing at a time.
Yeah, absolutely. But she should recuse herself because she clearly has some sort of very deep personal convictions about this particular case. I'll tell you, if she behaves that way with all the cases, and maybe that's what we need to try to figure out or find
see
out.
her history, that'd be interesting.
Is this how she always behaves, or did she pick Kelsey to be her little project?
Yeah. Again, I think there's got to be a reason. And I've heard from a couple of local attorneys that had more positive takes on Judge McCarthy.
Wow, that's impressive.
But limited sample. Who knows?
Right.
I just don't know. So anyway, this part is going through basically all of the medical information.
And how long, they don't know how long.
And this part here is critical here. The court ignored. Let me see if I can highlight that properly. Uh-oh, there's some more erring. There's some more erring going on.
Oh, no.
Watch out. The court also ignored the second to last sentence of Section 58A2, which provides the judicial officer may at any time amend the order to impose additional or different conditions of release. Further, the court erred in citing 58A4 as the applicable circumstance and found non-compliance. This was not a reopening of 58A. This was a revocation under 58B. That's different. Clearly, as set forth herein, did not conform to the requirements for such action. This court, the appellate court, could look just at that and say it was totally approached wrong, 58A. Therefore, we're going to approach it applying 58B and fix this.
It looks like the law wasn't even followed properly.
She just picked the wrong one and sort of got her where she needed to go.
Right. Urine testing, common tool.
I tell you, the judge is a common tool. That's what I think.
Yeah, absolutely. Unfortunately, the court's demeanor severely curtailed any elaboration from probation or counsel, culminating in the court preventing any further discussion by walking off the bench mid-argument of undersigned. You go, Bradle.
Yeah, it was just, again, circling back to that audio, you gotta listen to that audio. And I think the only reason that he was less forthright and clear about the alternatives is because she was stepping all over him.
Yeah. Oh, yeah. It's hard. Like I have said, I probably should have become an attorney because I'm the courtroom's like a theater, and I like the research and debate and all of that fun stuff. And
not too late.
Nah. I'm loving life now. But one of the things is like being in that situation with a judge that it rattles you when you're trying to convey a point or get a message across, and they're just walking all over you. Like I would have a really hard, I would probably get thrown in jail for contempt. That's
all right. There's nothing wrong with that. As we say, when we know we're going up against the judge that it might not work, take your toothbrush. Take a toothbrush.
That's right. That's right. Yeah.
It's an adversarial process, and sometimes that's between you and the judge, and you got to fight. And I think with this judge, I don't know really how Tim Bradle maintained his composure to the degree he did. He was she scurried like a rat off the bench, so he didn't have a lot of time to confront her.
I wish I could have seen Alan Jackson in that situation, because I think it would have been a little different.
I don't know.
She still would have left. He might have still been talking and saying, "I'm going to put all this on the record." And blah, blah, blah.
That's true. I wonder because that's why I wish there was some video. But did the clerk leave too? Did the court reporter leave? Did everybody just follow the judge out the door? It's very strange.
It was odd. Just boop, done.
Yep. And he really pounds on this 58A and what wasn't done properly, which I can't wait to see if they really handle that properly at the appellate level. Oh, another urge. Look at that. The court further urged when it misstated the
jackpot
standard
for you.
Yes, it is. For hearsay. Oh, yeah, that's right. That was another issue that she screwed up. What a shocker.
Amazing.
She was trying to apply the normal hearsay rule to some documents that were being submitted regarding alternate testing. And that email's hearsay. I'm not even going to listen to it. Well, the rules for these types of hearings specifically
totally
say you don't have to follow those kind of strict interpretations of the hearsay rule. And she said, what'd she say? This is an email from a probation officer, Mr. Tuesday. And we know him. We can't believe anything he says. And so the court gives that 0 weight.
And then he's like, excuse me, ma'am, I'm right here then. I loved that.
And he had been testifying.
Yes. Yes. That was precious when he was like, well, I'm happy to talk to the court now.
He's a good guy, that Mr. Tuesday. The rules concerning admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness or probation officer, perhaps.
You think?
Yeah.
He would be an officer of the court, is he not?
Yeah, and to make it even more ludicrous, the guy's right there. He's standing right there.
Good cause to just,
We've got, I forgot what, we're rolling through this. I don't want to hold you too long. Are you good? You all right?
Oh, I'm good. Yeah, I'm
you got
fine.
a minute? Okay.
Yep. We're good.
I don't even know what part of the world you're in. I'm assuming it's near. It's in the Northeast.
No.
Oh, well, when you spent all that time at the trial, I thought, so give me a time zone.
I'm Central Time.
Oh, okay. All right.
But I'm good. Yeah.
Okay.
Mr. Demeanor hasn't started dinner yet. He's waiting.
Okay. That's right. You got an extra hour because you're an hour behind me. Okay. So we'll finish this and then leave for another time all of the exhibits, which I suggest people get a hold of. We'll post them somehow. I've just given Missy something to do. Because it is one giant, beautifully constructed document. You don't have to be looking for bits and pieces on X, which drives me crazy.
Oh, yeah, I know.
Okay.
Yeah, post it, Missy. Post it.
Yeah, get these out there. 58.
Oh, I see bold. This must be important.
This must be important. 58B, a person who has been released after a hearing pursuant to Section 42A, 58, 58A, or 87, which is what applies here, and who has violated a condition of release shall be subject to a revocation of release and an order of detention. The judicial officer shall enter an order of revocation and detention if, after a hearing of the judicial officer, finds, one, if there is probable cause to believe that the person has committed a federal or state crime, obviously not an issue here, or clear and convincing evidence that the person has violated any other condition of release, and two, the judicial officer finds there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any condition or combination of conditions of release. In other words, she had right in front of her, under the law, the perfect roadmap to make this right.
Bolds. I like the next sentence.
Bold.
Bold sections are relevant to instant appeal. I love it.
Yeah, in case you were wondering, and even if I do this, now they're like double bolded.
Double
importance.
Yeah.
So basically reminding the judge, this is specifically how she screwed up justices. Okay. Yeah. She didn't violate any conditions of release. She was trying to avoid violating is really what she was doing. Yes. The Commonwealth, to its credit, recognized the situation as such and only wanted her to continue to be tested. Again, this guy was a bleep. And his name, I had it in front of me. It's like gobbledygook or gobstopper or something. Gobsmacked, something. He sounded like a very, I called his office this morning, basically, because I was sending out all my, how do I get a copy of this before we go on at 6?
Right,
my buddy at the clerk's office, responds to my email. Yeah, sure, no problem. And then 4:30, when I know he leaves, comes and goes. I got nothing. And then luckily, Courtney, who is so nice, is Tim's paralegal. She sends it, and then Tim follows up and says, "Did Courtney get that to you?" So they were great, and we're covered, and I was so glad. But I was like, "How else can I get it?"
Yeah.
So anyway, so we're talking here about
Mr. Gobsmack.
Oh, Gobsmack. Oh, he's like the baby. You know, he's like there it is. Gubatosi. There it is. See at the bottom there? Statement of James Gubatosi.
Oh, Gubatosi. Okay.
Gubatosi.
Yeah. He's Gobsmack.
Good Irish guy. Anyway, so I called his office and said, can I get a copy of this? What a shocker. He never got back to me.
Oh, imagine
Amazing.
that.
Yeah. But he was a real wimpy. And if you were to listen to him at the hearing and hear him, he never really was forceful about anything. He was non-committal at best, actually sort of kind of helping the probation guy at a moment. But if you read their response to the single justice petition, they were all up in arms at the hearing about how inappropriate it was to try to keep her out of jail for this violation, blah, blah, blah.
Well, it seems like that's almost a prerequisite for the ADAs in that area is to be Weasley. And, because Lolly didn't have a lot of oomph behind him.
And he was a lifer, never worked anywhere else. This guy is maybe a junior Lolly. Maybe he's on his way. He's on the Lolly track. So, Mr. Gubatosi. Yeah.
Who became the judge, shut down by the judge? Oh, this is good. To the contrary, Assistant Chief Probation Officer
January.
Tuesday.
Yeah.
Fully supported alternative testing means, but was completely shut down by the judge, who became increasingly angry that he was confirming and corroborate. Oh, I'm sorry. Should I say it like Hank says it? Corroborating the defense motion with his own personal knowledge.
Gosh.
Wow.
Yeah. So there.
And that's the truth. That's exactly what happened.
Yeah. And again, if you listen to that audio.
Oof. And this is, I think, what he was testifying to. Is it not my first job? Yeah, this was directly what his testimony was.
Hey, let me ask anybody. I know what Elmo means when we talk about trial, not just Elmo, not that Elmo, but in trial, it's the overhead projector. But yes. I don't know. This is some sort of central clearinghouse for violations or something. If anybody knows what that stands
acronym
for,
is.
Yeah, it's something law, something. I don't know, but it's the person that collects
legal management office or something.
That's good. That's as good as any. Excellent legal management office. I don't know. Exceptional legal management office.
Or maybe it's Essex. Aren't they in Essex? No, where are they?
They're in Essex. But I don't Essex law. Anyway, they get the info. Somebody would be Googling that right now. Somebody could be Gubatosing that right now. She unfortunately was unable to complete the test because she was unable to blow long and hard. In conjunction to the hour and 20 minutes, we also know, and I observed it firsthand, that whatever injuries are, and I don't know, and actually it really doesn't matter to me. When I was doing the installation process, that's so fun. This is Mr. Tuesday. He's like, I don't, it's not my thing. I'm not a doctor. I don't even know. So
I don't even know.
I had to research this. I kept seeing this phrase,
installation process,
and I'm thinking, what, you're putting in a new V8? I mean, what are you doing? What is the installation? What you're taking it and you're attaching it to the like some sort of cyborg. It's apparently just inputting them into the system. And I would suggest they change that description because it just sounds a little more invasive than that.
I had management years ago that you would get installed as a manager.
and obviously there are like, the Moose Lodge or church organizations, you're installed as a head poobah or whatever.
Exactly.
But that, again, I hadn't heard it in this context of the system and the equipment. So it just means, we're putting you in the system. All right. And so when he's there, he's physically there to do it. That's when he observed that, this is causing her some problems, but hey, not my job.
Yep. It doesn't matter to him. I
No.
love that. Yeah, she was not non-compliant. That the whole thing
No,
was
and here's the court asking that question. Court, any objection to any of the terms used by the probation officer? No. Okay. This is the court to the DA. I believe that was what that was. I think it was the court to the DA, or maybe it was the court to both parties. We have all the information. We don't deem that non-compliant.
Yep.
Again, I don't know. Let me read this again.
I did not get the impression that the ADA wanted anything other than a modification to the type of testing. That was the gist I got out of it. The judge is the only one that had some bug up her tail and couldn't get past it.
And what it sounded to me like was we just want her. She needs to comply with the conditions of her release. That was as non-committal, not this specific way to do it, not no other way except what the court believed. Just however we do that, let's do it.
Yeah.
And this is Mr. Tuesday continuing here. I think this is his understanding. I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test.
Good
That's
grief.
that. Mr. Tuesday has a way with his words. That's not non-compliance. Ooh, double negative. So he's saying that's compliance. That's
Correct.
someone and then the court jumps in. Well, that's your position. Remember that part where she jumps in? Well, that's your position. It's really up to the court to determine whether someone is compliant or not. Well, why don't you suck on this, judge? You're supposed to be relying on the experts, right?
Or evidence or testimony or anything other than just what you feel like you want to do that day.
The goal is to test and ensure that the person is sober, and we don't deem that non-compliance. More words. We never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was what? Subsequently passed. And then the judge spiraled off on his thing about randomness. Do you remember that?
Yes.
Because apparently they were scheduled. I think it was 4 times in a 24-hour period.
Or like every 4 hours.
Yeah, and they were scheduled, though. So it wasn't a surprise.
Absolutely.
She made it sound like, well, no, we want to surprise these bastards. We want these to be random so we can catch them.
Yeah. Okay, do random.
But that was never asked for. And that the probation officer called her on that, too, and said, well, that's not the default position is not random. The court has to specifically say random.
Yes.
And by the way, Ms. McCarthy Neiman, you didn't do it.
Oh, I'm sorry. I left you hanging. Sorry.
Oh, it's okay. Court, what do you mean we discussed? So she knows when she's going to be tested. This is the random thing.
Yeah, this is the thing.
Oh my God, she's just so loopy.
Court says it was random screens. Excuse me, Officer Tuesday. It was random screens. Now you're telling me she's on a schedule to get tested. Is that what you're telling me? Yes, we're telling you that. Naaman.
It was random that was ordered. Well, not by you, Goofy.
We created a schedule as we always do. Not in this particular case. We always do.
Yeah, we always default to creating a testing schedule up to 4 times a day. So you can do random if you want, but that's on you. And you didn't do it. Another delusion.
Delulu.
So
she doesn't. That's when she said, if you go back up there just a little bit, that's where she says, I want the test to be done randomly. I don't want her to know when the tests are coming. I want the tests to be done randomly.
That quote is in reference to what they expect the court to do if it's going to be random. Not that she did it. The only way we would enter a schedule is if the
court specifically said.
And she never said that.
No.
She never said that.
Because she only did half of her job.
You give her credit for half-assed.
Being generous.
Yeah. There's no such order on the probation contract, and undersigned recalls no such order. So then we have the ADA argument, which is a pretty beefy balance to the case here. I think we probably don't have to dwell into that too much. It's pretty clear. You got ribs, you got a deflated lung, you got hepatic trauma, and deep breathing is going to be a disability. Let's hope she's completely recovered from it at some point.
Sure.
and then
But
she'd be
even
relieved.
so, then you still have to accommodate.
Well, yeah, as long as it is, as it appeared at the time, to be a true disability, then you got to handle that, whether it's a temporary thing or
Yeah, she
permanent.
definitely has diminished lung capacity because of
Mhm.
the rib fractures, if nothing else, but she has other damage that was part of the issue as well. So,
Yep. And you mentioned her height and weight before, and all things are proportionate. Do you think she has greater or less lung capacity than Hulk Hogan? Well, no, Hulk's dead now, but you know what I mean, like a giant person.
right. Yeah. A
She's going to
bigger
have
person. Yeah.
even full strength. She's going to have a less lung capacity.
Less of it just because she is a littler person.
Yeah.
Yeah. She's no Michael Phelps going to be able to like be pushing
No.
that kind of air.
No. Nope. Okay. Oh,
No. Oh, footnote.
Let me see what reference we have for that. Hold on. Okay. And where'd it go? I don't see it.
Oh, it was just there. Go down a little bit more. Other way.
Oh, there it is. I see a top sentence. Despite these limitations, the Scram device was installed. Okay, that's obviously the health reference. Upon witnessing Ms. Fitzsimmons' inability to comply with the device's demands due to her medical condition, Assistant Chief Probation Officer Jeffrey, Tuesday, January, attempted to bring the matter right back to the attention of Judge McCarthy Naaman, the presiding judge who had imposed the conditions. However, Judge McCarthy Naaman had already left the courthouse for the day, and no immediate judicial relief was available. So, classic. Can we get her time card from that day?
She's like, deuces, I'm out of here.
Like, where's Justice Dewar? We have some briefs to go over.
Oh, yay.
Okay.
Oh, and then
alternates there, the Scram bracelets. And I looked into that. They are in Essex County approved for the bracelets. It's a company, it's called Paymer, something like that, but they are approved. You can only use.
How do those work? They just wear
well,
them?
here's the complaint about them. They measure sweat or moisture, and apparently they are more susceptible to error than the breathalyzer or the urine. So I think that's probably not a great alternative. I can see blood or urine being approved.
Sure.
And you can pay these people just to show up at the house and do it. She doesn't go anywhere. She is on house arrest.
If that's what you're insisting on.
Yeah. And so whatever Justice Serve TV pays for, that will be handled. But I can see I'm anticipating a problem with the transdermal bracelet because it does have some less specific
reliability.
Issues. Exactly. Transdermal. Look at this. It's like we're reading ahead. I've never seen this stuff.
Oh my gosh.
Transdermal Scram bracelets, although not currently available in Massachusetts, is like a breathalyzer for the ankle. They are available. There's a vendor. I looked it up.
Interesting.
Paymer, I think, is what the name was. Somebody can double check me on that. It was like Paymer. The Scram continuous alcohol monitoring bracelet provides 24/7 transdermal alcohol testing for hardcore drunk drivers. All right. High-risk alcohol and domestic violence caseloads by automatically sampling the wearer's perspiration every 30 minutes.
Wow.
Scram bracelet eliminates testing gaps and encourages accountability. Higher compliance rates, blah, blah, blah. They don't, of course, because it wouldn't help their cause, mention that it is slightly less reliable because of the sampling is sweat.
Sure.
Conclusion. Court should have granted release. Well, let's go ahead. It is the conclusion. So I'm getting nauseous here. Sorry, going up and down. The court should have granted release on personal recognizance with standard stay-away orders. The court clearly dispensed, and those stay-away orders are in place. The court clearly dispensed with the safeguards that bail be revoked only after finding violation of terms, and that there be no combination of conditions that would allow the defendant's release. The court did not further the bail statute's purpose of establishing the right of the accused in most circumstances to be admitted to bail. And this is not a murder case.
No.
If the court believes there should be conditions set, there are ample alternatives to Section 58A incarceration of Ms. Fitzsimmons, all of which were assiduously avoided by the trial court. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court address the bail determination de novo, consistent with the applicable case law, grant Ms. Fitzsimmons liberty with personal recognizance and a stay-away order from the alleged alleged victim under Section 57, no finding of dangerousness, or Section 87, bail terms imposed with agreement of the defendant of the bail statute, and vacate the balance of the trial court order, including, here's some bold for you, the provision handicapping the probate and family court from handling the custody and visitation decisions in this case. That's very interesting. Very interesting. Remember, in their joint agreement, again, subject to changed circumstances,
Right.
they kind of handled all that stuff. And now they're saying, don't let that court, don't let Judge Black, if she keeps jurisdiction. It's interesting. Interesting. I'll have to quiz more about that.
Yeah, because I'd be curious to know, would that then give her the right, regardless of the situation or the pendingness of this case, the ability to have custody of some kind?
I don't know. I don't think they would paint themselves on a corner like that. It seems like it would always be a family court question.
Sure.
Let me read that again. Make sure I'm reading it properly. Personal recognizance and stay away order from the alleged victim, or Section 87 of the bail statute, and vacate the balance of the trial court order, including the provision handicapping the probate and family court from handicapping them from doing it.
Yeah,
okay. Yes, not
making sure that she will be able to. Correct.
Yes, that makes perfect sense. I'm just dumb. I missed that. Okay. Yeah, that makes perfect sense.
It's all right.
I guess there was a trial court order. I would never imagine why the trial court would prohibit the family court from doing a family court thing.
Absolutely.
It makes no sense.
Yeah, there you go. But it's Massachusetts.
It is. And it's Judge McCarthy.
Name it.
And number 4, send the case back to the Essex Superior Court before a different judge for the reasons set forth above and the fact that she is a loon.
Yeah, okay. I don't think she knows. Maybe she has liquid lunches.
Once again, lunch with Dewar.
That's right.
She says, I'm having lunch with Dewar today. People think she's going to see Justice Dewar. And really, she's just filling her glass. Wow, that was exhausting. Thank you for helping get through that.
I didn't do much.
I need to crack this open. I told Linda, if I have enough shots of this, I can understand her texts. Yeah.
You leave Linda alone. She's not here to defend herself.
I know. People will be all over me, I guarantee it.
Well, I have to tell you.
She's doing the Lord's work now. So
absolutely. And I have to
Lord
tell
Aiden
you.
Carney.
Tonight, I feel like I've made it because shortly before I came on your show tonight, I happened to notice for the very first time, someone on the Twix had blocked me.
Nice.
And the only reason they blocked me, well, I did. First off, they put a comment that said, "Oh, immediately unsubbing because I was going to be on this show."
Oh,
and saying, that they don't do crazy or something like that. And so I went and I'm like, well, I got to go look at their profile now. And so I looked at the profile and it said, "You've been blocked." I was like, wow. Oh my goodness, this is such a momentous occasion.
Can you tell us who blocked you? Who blocked you?
Seasons.
Yeah.
Seasons is her name. I don't know. She has I can't remember, 164 followers or something like that. I don't know, but immediately unsubbed. I was like, well, that's unfortunate for you.
Yeah. That's what I say. And I don't normally get down in the gutter with some of these folks because, well,
I never do.
I'm not 12 anymore. But there were a couple that, when Linda announced and Aiden announced the affiliation for this Atlantic City case. And we will talk about that much more when we're able. There's a matter on Wednesday. So one was just so stupid. It was, they have even fewer subs than Young Jerks. So I immediately thought that's your criteria, apparently, for legal representation. So if that's
I saw
true,
it. It was fantastic.
If that's true, Mr. Beast, get ready for a call because they got you dialed in. It's just so stupid. Anyway, I try not to get in that mess because
I never do.
I'm not 12.
I head on down the road. It's energy I don't need to be messing with, so I'm good.
Yeah.
But I thought it was funny right before I came on here that I saw it. I was like,
"You're out. Oh, you're blocked."
I need to tell you guys.
Yeah.
Gotta tell you what happened.
Yep. It's a strange universe. I don't know if you found that, but it is a strange universe.
It's a little backwards. It's bizarro world. A couple weeks ago, I did a live stream with another individual, and it was all about cyber bullying, cyber stalking. And it was interesting for people to hear in that live stream what is actually against the law. And when you're participating in online feuds and that you're participating in cross-state commerce, even, and people don't realize that. They don't realize what they're actually doing when they're online. So,
well, I've learned, among other things, there's no IQ test to get online. And
well, and Bedro talks about the Twitter law school all the time. So there's that.
Yeah. And the same thing that makes it a beautiful thing, that access, opportunity, and, it has a downside because any lunatic can hop on. So
absolutely.
All right. Well, so I was going to ask you some personal questions, and I never got to. Is Demeanor your last name, or is that just your stage name? You're keeping that quiet because I know you're in the witness protection program. I get that.
Exactly.
That. It makes perfect sense. All right.
Well,
I think it's very clever.
Thank you.
And I'm so glad that we bumped into one another. We actually didn't meet while we were both at the courthouse.
No.
But immediately after, I said, "Oh," because you had the whole Aunt Debbie, Jimmy.
Yep.
Which was very funny. Question. Hello, Madeline, Madeira Beach caregiver. Pardon my naivete, but what
the heck is Kelsey
even ordered?
Oh yeah, we don't know.
Yeah, and that's again, it's all based on, as far as I can tell, the bachelorette party, which was incorporated into the affidavit by the alien, and the judge latched on to that. Now we don't know, and you made a good suggestion. She may have a history of making those kinds of conditions with anybody that she gets a whiff of alcohol around, right? We don't know.
Yeah, I don't know anything about Naaman. So,
okay, well,
yeah.
Thank you, Madeira Beach caregiver. Always a pleasure. And I've been really horrible about looking at comments, questions, anything else, but Missy's used to that. Okay. I think I cleaned up all of that stuff. All right, then. We should do this again.
Yes, and make sure everybody tomorrow morning. I've been doing
that's something we didn't get around to doing, did we? You want to do that for a minute? You want to do that for a minute?
Fine.
Yeah, let's do that, because you're tell us about this trial that you're doing.
So I'm replaying the Raoul Valley trial. It actually came to a conclusion in July, and I'm redoing it because the jury was hung on several of the lesser charges, and they are continuing to prosecute him for these lesser charges. It is a case of 16 and 17-year-olds. Alcohol is involved. There are parties. It's feuding high schools, and unfortunately, one of the young teenagers loses his life because he's stabbed. And so they're all part of a lacrosse team on opposing schools. That's kind of what prompted me to have an interest. My husband is a former lacrosse coach. My son played lacrosse for, I don't even know, from the age of 10. I feel like he had a lacrosse stick in his hand his entire life. So that interested me. And then it's just been fascinating. There's a lot of eyewitness testimony. We got through today on my channel the first almost 3 full days of testimony, about 10 witnesses. It's I will say this, it's refreshing to see police and law enforcement doing their job the correct way. So there is at least that to look at. It's a
Connecticut case, not far from me, about a half an hour up the road. I had meant to go up. We talked about this before. I meant to go up, but I was embroiled in something going on in Massachusetts. I'm not sure what. But just for a little bit of a sneak peek, this happens to be the defendant, and he takes the stand.
That close to you?
Yeah.
Your Honor, I'd ask the witness to demonstrate with me what
Did
he
you
was
hear him,
experiencing
Janet?
at that point.
Yes.
Okay,
good.
Comfortable demonstrating, that's fine. Just
This was
please,
fascinating to me.
Keep it in the well. Thank you.
Will you come down here, Mr. Valley, please?
Please, if there's going to be any statements, just make sure that you're keeping your voice up so the microphones can catch your statements. Thank you.
I'm you, where is Ryan Hines?
Right here.
And
Ryan was the
Ryan's
victim,
the
right?
same size as you?
At the time, I was very small.
Ryan was one of the victims.
Okay, was he the one that died or no?
No,
Okay.
no.
And
Jimmy McGrath is the
you're
one
Ryan
that
Hines.
lost his life.
What is he doing?
First, we're just talking.
At some point, does he do something else?
Yes.
What?
After he starts yelling, I stuck my hand out as I was backing up from everybody, and he smacks my hand out
Where were the other people that you've said were around him?
to my sides, in front of me.
What did you do when he smacked your hand down?
I started slowly backing up before that, and I continued to try and back up.
Take a stand.
So, obviously the jury liked this kid, right?
He's pretty easy to like. It's such an odd case. I watched a majority of it the first time around. And of course, this time, because I'm replaying it as a live stream, I'm watching all of it. And there are some tidbits that I didn't catch the first time. And there were several times today that I went, what? What is happening right now? What is this testimony about? He had a fantastic defense attorney. I'm so sad that he cannot retain Kevin Smith the second time around. He was very, very good. I rather liked him a lot.
Yeah.
So
And that's a big issue now because there's a hearing next week. If I end up going up there, can I do some special reporting for Ms. Demeanor?
absolutely.
Okay. Because we're going to find out I guess they have an opportunity at that point to say we're not going forward, but that doesn't sound likely. So now it's more about his representation, right?
I think that's what it's about now. I know when he appeared before the court last month, he asked for, I can't remember, I think it was 2 months or something like that. And the court said, or I'm sorry, no, it was earlier this month. He asked for a month and then the court said, I'll give you 2 weeks is what it was, because his hearing was on the 3rd. And to try to find an attorney. And he was very respectful. He was very pleasant, calm. And that's what you saw in that clip is the only way I've ever seen him remark on anything. And it just, yes, I understand that an individual lost their life, but it's so frustrating. Like, what do you do in this situation? They were all young kids. There weren't parents around. There was excessive drinking. Lots and lots and lots of bad choices were made.
Yeah.
But they were teenagers. He was 16 and 17 years old. Like,
Yep. And so the fact they want to press forward, that's very interesting. So
yeah, there were 4 individuals stabbed, and the 3 other individuals are the lesser charges that they're going forward with.
okay. All right. So everybody check that out on Ms. Demeanor's
do.
site. When do you fire that up? What time?
I'll be on 8 a.m. Central Time tomorrow morning, so that's 9 a.m. Eastern Time, and we'll go probably until about 5 Central, 6 Eastern.
Okay. What time is that in England? So we have some people there.
I have no
Might wanna-
idea.
might wanna
I
tune
hope
in.
they can convert it.
All right. What Zulu time is that? All right. Thank you, Ms. Demeanor.
Thank you so much.
Such a pleasure. So fun. I say we have as much fun as we can talking about these horrible things. But
Well, that's what you got to do.
yeah, you were helpful because
Thank you for having me.
a pile of paper that, again, Missy, I know will be posting. So anybody wants to look at it in detail, they can. Thank you. Let's stay in touch.
Thank you.
Take care. All righty then. Guest host week is continuing tomorrow. What's happening tomorrow? Oh, tomorrow's Veterans Day. And so we have a very interesting guest that she was involved with a program that was designed to increase kind of the camaraderie and the development of military. It was called the Pinup Program, and it's exactly what you would think. They kind of reached back into the 40s and 50s where the pinups were a big part of the military. Then every guy had these pinup girls posters laying around. And so she was part of that renovation. She's in this, all of these pinup girls in this new program are in the military. So a little bit of a change from what happened the first time. Anyway, also, don't tell anybody, she has some interesting info on the Farwell brothers. Oh, we're back in Massachusetts again. Yeah, Matthew Farwell, now charged in the murder of Sandra Birchmore's unborn fetus. and of course in her death as an adult, but they don't have in the federal statute, doesn't have a murder statute. So they have applied it to the death of the child, but not to the Ms. Birchmore. And so it's going to be amazing on many levels, not just I think a proper homage to Veterans Day and all of those who have served. Thank you for your service, but also some insights that nobody has heard before about the Farwell family. Remember, it's Matthew Farwell and his brother. What's his brother's name? Robert, Richie. We will get all those details. We will, of course, keep you posted on Linda Kenney Baden, what she's up to some degree. She'll be back. I think she's going to be back later this week. But let's go day at a time. See how it goes. Let me read that. Let me see that. Let me read that. That's her. There she is. She's going to come on. So I don't know if she's going to be wearing a flag, but she's coming on. It'll be Veterans Day, and it'll be quite fun. So join us then. Have a great night. We went a little longer than usual. I apologize, but I really wanted to get through those documents. They just come in, and it was important that we do that. So best of luck to Kelsey Fitzsimmons. We'll bring you up to speed on anything new that might happen there. The reply by the Commonwealth is due next week, 10 days later. And once that happens, the court will either ask for a hearing or they'll rule. I've always said, with the timing as such, Kelsey Fitzsimmons theoretically could be out for the holidays. So keep some good thoughts in your mind there. That's going to do it. Michael Bryant here, Justice Serve TV. Please try to do the right thing.
Riding flames, they charge with